Namaste friend, welcome back to Kaydanivato. Today we are exploring the chapter 14 of the Bhartiya Nagrik Suraksha Sanhita, focused on jurisdiction of the courts in the inquiries and trials. We will walk through this chapter section by section to clearly understand how and where trial take place. So let it break down. Chapter 14, Jurisdiction of the Criminal Courts in Inquiry and Trials. This chapter covers the section 197 to 209. The main content of this chapter, section 197, ordinary place of the inquiry and trial. This defines the default location for inquiry or trial, typically where the offence occurred. Section 197 is explained that when the inquiry or trial should be tried. Section 198, place of the inquiry or trial. Courts have flexibility to decide the venue based on the convenience and relevance. Section 199, offence triable where the act is done or consequence ensues. If an offence results in consequence elsewhere, the trial can take place at the location where those consequences happened. Section 200, related offences. When one offence is linked to another, both can be tried together at a suitable venue. Section 201, certain offences special rules apply for the venue determination in certain specific types of the offences. Section 202, electronic communications, letters, etc. Offences committed using electronic or postal means can be tried where such communication was received or accessed. So section 202 clarify that if the offence offence done with the electronic communications, then at that time where the trial will commence. Section 203, offence of the journey and voyage. If a crime is committed during the travel, like on a train or ship, the place of the trial can be the destination, origin, or any intermediate point. Section 203 is clarified that if the offence made during the journey, at that time where the trial will commence. Section 204, offences triable together. Multiple offences connected by the same occurrence may be tried in a unified venue to ensure consistent adjudication. Section 205, Sessions Division Orders. High courts can order that the certain cases be tried in different sessions division for administrative convenience. Section 206, High Court's decisions. When there is a confusion about which the district has jurisdiction, the High Court can determine the appropriate venue. Section 207, beyond local jurisdiction. Summons or warrants can be issued even for offence committed outside the local boundaries. Section 208, offence committed outside the India. Trials for the offences committed abroad can still take place in Indian courts under the specific rules. Section 209, evidence from the abroad. Indian courts can receive and admit evidence relating to the offences the occurrence outside the India. So this chapter defines that a clear framework on where criminal proceedings should take place, whether within the India or from the abroad, and clarifies when the courts must handle the trials beyond traditional jurisdictions limits. So friend, this was the chapter 14 of the Bhartiya Nagrik Suraksha Sanhita 2023. If you find that this breakdown is useful, then like, share and subscribe this channel. We'll meet soon with next chapter. Till then, bye. Take care. Jai Hind. Stay connected with Kaydani Vato.